Rise IT is a global software service company that provides software consulting, staffing, and governance risk compliance services. With over 1,000 employees and consultants in the United States, it focuses on cloud, workflow automation, and business intelligence. Our subsidiaries include iTech, SmartWorks, Cox Little, and the Excel Group. My name is Dobrina and Wasden, and I'm the General Counsel at Rise IT Solutions. I oversee all in-house immigration and compliance matter for our company. At Rise IT, we are proud to have a dedicated team of senior immigration law experts who provide our employees with top-notch immigration assistance. And today, it is my pleasure to introduce John Wasden, an immigration attorney who represents corporate clients and provides strategy to overcome immigration denials, including cases of federal court under the Administrative Procedures Act. For the majority of his career, John worked as an attorney for various U.S. governmental agencies, where he defended immigration regulations and decisions under the APA. His last position in government was with the Administrative Appeals Office, focusing on employment-based legal issues and advising on litigation in these areas. Currently, John is a managing attorney at Wasden Law. John, welcome to the podcast today, and I'll dive right in with the hot topic in the immigration world today: multiple registrations with this year's cap.
Yeah, I don't think I remember a headline that was in every single major news distribution or magazine, newspaper, website. Everybody was covering the multiple registration issue. And it's a hot topic. And because it has so much media, the government is definitely paying attention to it.
Right. Can you walk us through really quickly as to what happened with this year registration?
So with this year's registration, we had 770,000 pre-registrations, which was a huge increase from last year by a couple 100,000, and was about 400,000 or 500,000 more than years prior before they had the lottery the way they're doing it now. So after the first year they ran the pre-registration, they put in this rule without really going through notice and comment rulemaking like they should have, that you can't collude with another company to increase the odds of a beneficiary getting selected in the visa. So a lot of companies rolled the dice on that and thought they could get away with it. Not a lot. It's probably a small handful of companies rolled the dice and thought they could get away with it. But what we're finding now is that the data and the software they have is pretty good. Mm-hmm. It's actually one of the few computer systems I've seen in the government that works the way it's supposed to. And what they're doing is the first step is they're picking up on these multi registrations that are overlapping between different companies. And if they're picking up a trend, like if you have 30 employees in company A, 30 employees in company B that are all put in the pre-registration, that's going to be a huge problem if they're all overlapping. Random overlaps where the employee is shopping around, not a problem. It's where you have a significant pattern of overlap that they're going to start focusing in on you.
So if I have an employee that was registered by 2 or 3 employers, but I as an employer have no idea about it, then that should be fine in this case, at least for the company.
Yeah, definitely. That should not be a problem the way the collusion rule is written, because you've done nothing in that situation to intentionally try and work with another organization to increase his odds. He just did that on his own.
Okay. And having said that, how likely are criminal investigations and prosecutions?
So, like I said earlier, there has been a lot of media attention on this. And one thing I know about government, nothing motivates them to act quite like media attention. So because the attention and because the scope of the problem this year, I strongly suspect that they will go after people with criminal charges and criminal investigations and try and prosecute people for visa fraud.
Mm-hmm. And do you think that will happen in the next few months, the next year, couple years?
So what we're saying, we saw this in another case in New Jersey dealing with the B1 visas, is that first they send in FDNS to do these site visits. And really what they're looking to do is start collecting and gathering information. And then they take that information and send it to ICE, who then builds the criminal charge or the criminal case and investigation. So the process is going to take a long time for them to figure out, how they're going to investigate and what evidence they need and how to get it. I wouldn't expect to see the first criminal charges probably for a year, but the criminal investigations could be starting at any point before those charges are dropped.
I see. And in these situations, how can we fight this issue proactively instead of waiting for that criminal complaint to hit our desks?
So I do think I mentioned this a little bit earlier. The attestation rule that where you attest under penalty of perjury that you are not colluding didn't go through notice and comment rulemaking. There's a way that you create what the APA calls punitive final agency actions or sanctions. And so they have, especially when it's a sanction where they're harming somebody and they're taking action against somebody, they have to go through notice and comment rulemaking. Their failure to do so in this case, I think, gives us a good way to fight this. And if we can get a decision on this civilly, it should preclude future prosecutions.
I see. Yeah, that's a good strategy. But that doesn't mean that for the next cap, people should go and collude and file multiple registrations. From what I'm hearing from you.
Yeah, it's not worth the attorney's fees and having to defend yourself to try and get away with it. It's just not worth it.
Right. And you mentioned FDNS. How should companies prepare for FDNS site visits? And what is a site visit? If you can go into that a little bit in more detail.
Yeah, sure. So the site visit usually kicks off with an email, a phone call, an in-person visit, sometimes to the employee's house, usually on a weekend morning, trying to catch them off guard, catch them at a time where they're not expecting it. And they'll ask for a whole bunch of things that have really nothing to do with the adjudication of the visa. They're asking for things that regarding pay, regarding the length of contracts, which they're not allowed to do during the petition adjudication process. But on the back end, they're doing it, and they're trying to revoke as many visas as they can through the site visit program. Now, FDNS is the organization within USCIS that runs the site visits. They're not adjudicators. They can't revoke, and they can't actually take any action on your visa petition. They just refer it to the service center, who then decides what to do with it from there.
Mm-hmm, mm-hmm. And are they random? That's what they say. It's random site visits, but
allegedly.
Allegedly.
I will say that my clients. So I do a fair bit of defending FDNS site visits. My clients that have come to me post the multi-registration issue have seen an amount of site visits that can't be explained statistically as random. And so I think anybody that's in that multiple pre-registration problem should expect to have a heightened level of FDNS visits, because what they're doing is they're looking for that information to build a criminal case.
Right. And I know we are not here to give legal advice, obviously, but what would you tell companies that are part of that multiple registration problem right now? Should they file? And if they file, what should they expect?
So the two things that would make the most sense to me in this situation is if you have colluded, and if you have, I mean, it's
Right.
not a secret to you if you've done that. If you've colluded, I would not file any petitions this year. There's a two-step process. You've got the attestation under penalty of perjury that we have some legal arguments about, and then there's the attestation and signature under penalty of perjury with a petition. Let's limit your damage at this point to that first step, and let's try and get you off the radar. But if you file all of those petitions, you're going to get noids in every single case, and I've seen it happen. And you'll get denials or revocations on all of those. So it's just really not worth the money and time to file these petitions if you're in that situation.
Right. And do you think that would prompt further USCIS or DHS investigation into these companies?
The ones that don't file?
No, the ones that they file.
Oh, yeah. They'll be going after the ones that file because you've drawn attention to yourself at that point. And so the people that don't file are not drawing so much attention to themselves, so they kind of decrease their chances of any negative repercussions.
Right. And going back to the FDNS, I mean, since they're part of all this collusion, why should employees be careful with interacting with FDNS? And as an employer, what should I do if the FDNS comes knocking on my door?
So, like I said, I defend a lot of FDNS investigations for companies. And the opening line in every email I send to the officer is something along the lines of, "Thank you for inviting us to participate in your voluntary program." And then I say, "See attached." And I attach a screenshot of their website saying, "Participation is not mandatory. It's purely voluntary. And if you choose not to participate, they're required to end the site visit." And so I just put that right up front as we don't have to give you anything. And then I go through and I color code their requested document list and explain in the email why the things in blue we're not giving them because there's a legal argument for why, red, yellow, and then black I'll usually give it to them. So the reason why employees should worry is because the way USCIS has created the system, the enforcement system, really the only people that bear the brunt of any of this is the employee. The employee loses their visa. The employee has to leave the country. The employee loses their CAP H1. The company really, they don't have a lot of ways to get at the company. And it's frustrating because in the whole process, the employee is largely the innocent party that didn't do anything. Where it's really creepy is, well, I've seen this happen several times where an employee, they ask for pay data, pay information, which you're not required to give them. The employee gave the pay information. His salary was 120 on the LCA. He got 119, and they tried to revoke his visa for failure to maintain status. Why that's such a problem is that the law explicitly says the employee does not lose status in that situation, but actually has a cause of action to go after the employer for that being shortchanged. And USCIS is completely screwing up people's ability to seek redress and is really discouraging people through their actions from reporting wage violations.
Right. Okay, so there are consequences of those FDNS site visits, and from what I'm hearing, obviously the employers need to be prepared and advise their employees accordingly.
So the thing that we usually do is we have a meeting with all the employees and go through and explain what FDNS is, what they're trying to do, what their rights are, what their responsibilities are in the process, what to do when a site visit happens. Just because they need to kind of have that knowledge ahead of time. If you wait until the site visit has already happened, it's going to be too late because
Right.
the employee is going to be flustered. The employee is not going to know what to do and may say something that's incorrect under stress and may give something away that should not have been given away. So education of the employees, I think, is key.
Is key. Yeah. Do you have any last words of advice to companies and employees in this multi-registration issues that we're facing?
So for the multi-registration, I don't know that the employees have much to worry about, just because there's so many of them and it would take too much energy on the government's part to go after the employees. The employers, I would say, make sure you have your attorney doing all of your site visits from FDNS, and potentially it might be worth talking to a criminal attorney that works in the federal system just to have them there so that you can call them if things do go sideways.
Okay. Well, John, thank you so much for joining us today. That's all the time we have. And thank you to all the listeners. If you want to learn more about Rise AT Solutions, our innovative projects, and discover new opportunities, you can follow us on LinkedIn, listen to our podcast on Spotify, YouTube, Apple Podcasts, and don't hesitate to reach out. I'll see you next time. Be well and do good. Thank you so much.
Take care.